Welcome, everybody. Thank you for joining us on this webinar today, Terminating Employment, Reducing the Risks. Margot will be helping me with the webinar today. I'll run through the first part of the session. Margot will run through the second part, and then we'll have some opportunity at the end, hopefully, for questions and answers. You will all receive a copy of the recording and the notes relating to the webinar. Okay, we might move into our acknowledgement of countries. So we at HR Success think it's very important to acknowledge the traditional owners of the land on which we meet today. We pay our respect to elders past and present. We also extend that respect to any Aboriginal and or Torres Strait Islander people who may be with us today. Thank you, Margot. Okay, a little bit about us. So we know most of you, but there's some new people online who great to see you online with us today. So a little bit about us. Margot and I have both been working in HR for 30 plus years. We don't like to talk about that too much, but suffice to say we've got plenty of experience. A lot of that experience relates to the area that we're talking about today. Unfortunately, terminating staff, it's an inevitable part of running a business. It's important that you get it right. So we've had plenty of experience that we're able to offer you today. So HR Success was established in 2007, so we've been around a while. We provide generalist HR support and recruitment support to our clients, predominantly in Western Sydney, but we certainly have clients further afield. Key difference of our support is that we provide our support with no retainers or lock-in contracts. We actually rely on the quality of our service to retain our clients. We're a small team, particularly at the moment. It's just Margot and I. So if you call us, you're chatting with Margot and I. So we get to know you, you get to know us. And I think that's a great foundation for us to provide quality support to you. We also have a couple of other brands, Success Through People and Short and Sharp Training. So I think there's some links to those at the end of the presentation. So we'd encourage you to have a look at those at some time in the future. Thank you. Okay, might move on to the next one, Margot. Please.
Giving it my best shot. It's a bit slow. I apologise.
Thanks. So the session is being recorded, so you'll all get a copy of that once it's processed. If I can just ask you just to manage any background noise and so on, if you're not talking, if you can just please mute. We will take some questions throughout. If you've got a burning issue that can't wait to the Q&A at the end, then please feel free to use the chat function. Margot and I will keep an eye on that, and if there's relevant questions or issues that people want to address, we'll identify that and bring those into the discussion. As I said, you'll receive the recording and the presentation, and you'll also get our new guide around managing the risks of termination for SMEs. So we're quite proud of our little guide. We think it's a good product and will really be helpful to our clients and others. So you'll be the first to receive a copy of that after today's session. Okay, so what are we covering today? We've got a lot to cover in a short space of time. Frankly, this could easily be a half day, if not a full day session, but we're cramming a lot of the most important stuff into an hour. So the main agenda items that we're covering today: unfair dismissal claims. What are they? How can you avoid them? How can you manage performance and conduct in a way that reduces the risks relating to unfair dismissal claims? So that's the first part of our program today. We'll also talk about summary dismissals, which is terminations without notice or warning. So it's important that we understand the parameters when it's appropriate to perhaps look at summary dismissal, when it's not, and what are the risks involved. And we also want to talk about something called general protections claims, which in our experience, a lot of employers are not aware of, but they are in fact a significant area of risk to your business. So we need to cover those as well. And of course, we've got some opportunity for Q&A at the end. One thing that we're not covering today is redundancies. So redundancies is obviously another manner in which you may terminate an employment relationship. It's a really important area. And as a result of that, we'll actually be putting on another webinar, probably February, something like that, that'll deal specifically with redundancies and help you manage your obligations in regards to those. So keep an eye out on your emails for that webinar in early 2025. We will say as well, just on redundancy, although we're not going to cover that in detail today, sometimes we find employers look at redundancies and think, oh, crikeys, it's all too hard to manage performance and conduct. I will just make somebody redundant. Uh, yeah, just a word of caution about that. Redundancies can be complex. They have their own set of obligations and responsibilities. So be sure that you seek advice if you're looking towards redundancies. Redundancies shouldn't be used as a shortcut for managing performance or misconduct issues. Okay, just also by way of general information, the information that we're sharing today relates to those covered by the Fair Work system, which is 90+% of people. It doesn't cover some in public sector and defence forces and those sorts of things, but I don't know that we have many of those people on today. I think we're pretty much all in the Fair Work system that are on the call today. And just a precaution, this is general information, not formal or legal advice. Of course, your own circumstances may impact the obligations that you have and just how to manage risks. So if you are looking at terminations, we strongly suggest you seek professional advice. Okay, well, let's move on then into the unfair dismissals part, the first part of our program. So I guess the first thing is, why should we be concerned about unfair dismissals? And one of the reasons for avoiding them or seeking to avoid them and mitigate the risks is just the time and hassle involved. If you get an unfair dismissal claim, you need to respond to that claim in a formal way to the Fair Work Commission. You then need to go through a conciliation process. You then need to, if it doesn't settle at conciliation, you then need to go into quite a formal process of arbitration, which generally involves considerable cost and legal support and that sort of thing, documentation of evidence, the whole shebang. So you just want to try, if you can, to avoid the time and hassle and the professional fees that is associated with all of those things. Another reason to avoid them is potential reputational damage. So I had a client the other day who decided to settle a matter, and one of the primary drivers for that was that they didn't want it to go to arbitration. They felt that they had a good case, and they did have a good case, but they just didn't like the fact that their business name would be on the public record as a respondent to an unfair dismissal claim. So, there is reputational damage potentially around some of these things as well, which many businesses are more inclined to avoid, of course. And then, of course, if it does go through conciliation and keeps moving through to the arbitration process, you're then in the lap of the commissioner, who may or may not be aligned with your way of thinking. So once it gets to arbitration, it's completely out of your hands. They can make any orders that they want. They may seek to reinstate the person in your business, which on many occasions is problematic. They could award damages of up to 6 months' pay, so that's often a considerable expense. In cases where they feel that your defence of your actions has been unreasonable, they may seek that you pay part or all of the applicant's costs. Now, that is a bit unusual, but it can happen. It is a risk. And then beyond compensation to the employee, the Fair Work Commission can, if they choose, issue fines for breaches of legislation and process. So for all those reasons, you want to try and avoid unfair dismissals. So there's a few key definitions that are important in this sort of thing. So one is the definition of a small business. So as we move through today's session, you'll hear us refer to small businesses. Small businesses are defined as those that have fewer than 15 staff at the time of termination. So that includes the person whose employment is being terminated, and it also includes any systematic and regular casuals. And it also includes employees in associated entities. So if you have multiple companies, then it's 15, including all of those associated entities. And the other important thing with that is that it is actually a head count. It is not full-time equivalent. So if you've got a bunch of part-timers or regular casuals, they all count as one. The fact that somebody only works 1 day a week is doesn't come into the equation. It's basically a head count. Associated entity has the meaning given to it in the Corporations Act. I won't go into that any further at this point. Another thing that you might hear us talk about is the qualifying period or the minimum employment period. So this is the period of service after which a former employee can lodge an unfair dismissal claim. Now, in the case of a small business, it's 12 months. In the case of other businesses, it's 6 months. So what that effectively means is that if you're in a small business and you terminate somebody who has not yet achieved 12 months service, they technically cannot apply for unfair dismissal. Now, the reality of it is, which drives me a bit mad, is that the Fair Work Commission will still accept a claim, but you should be able to object to that claim fairly easily and have it dismissed. So you've basically got 12 months after somebody starts to sort them out, and hopefully it works out. Otherwise, you can terminate them. The risks are less. They're not non-existent. There are still risks, particularly around general protections claims, which Margot will talk about. So it's 12 months in the case of small business and 6 months in the case of other businesses. So once they've achieved that period of service, if they're terminated after that, they have every right to lodge an unfair dismissal claim. Busting a myth, something that we often get employers often talk about is that they say, oh, well, I can get rid of this person because they're on probation. The probation period, we still recommend that employers have probation periods and put them in their contracts and act them as they go about their business. But in reality, they don't have any legal standing anymore. The thing that is important is the qualifying period or the minimum employment period, which is either 12 months or 6 months. Whether or not they're on probation does not have any impact whatsoever in terms of their rights to access unfair dismissal or any other claim. So don't rely on probation periods. Have them because people know what they mean and they're useful, but they're not going to give you any added protection. Okay, so let's move on to how do we actually avoid an unfair dismissal claim. So the best way to do that is really to ensure that if you are looking at terminating somebody's employment, that you go through an appropriate process. So the key defence to an unfair dismissal claim is being able to provide evidence to a commissioner, if required, that your action was not harsh, it was not unfair, and it was not unreasonable. So a couple of concepts relating to that. One is substantive fairness. Does the punishment fit the crime? Okay, well, somebody came in with an inappropriate item of clothing. Okay, so that they were wearing some tatty old t-shirt or something, and you thought that that was not professional, that was not in keeping with the standards of your business. Moving straight to termination for something like that would probably be seen harsh. Other things that come into play there might be length of service, previous warnings or previous issues that you've had concerning the person. So essentially, you need to think, does the punishment fit the crime? The other key concept there, which I'm sure many of you have heard about, is procedural fairness. So that's making sure that the person's you've given them a fair go to redeem themselves and to improve. And the tips that we will actually cover now, they are largely about ensuring that you have implemented a procedurally fair process. Okay, so what are those tips? How can you effectively manage performance and conduct in order to protect yourself against a potential claim? These are in no particular order, folks, but just make sure that you've got all of these covered insofar as you can. So first of all, you need to have a valid reason for the dismissal. The reason for dismissal needs to relate to the person's performance and or their conduct and or their capacity. They just can't do the job that they're employed to do. So they are valid reasons for dismissal. Disliking, not agreeing with somebody's political affiliation, not agreeing with their religious beliefs, getting rid of them because they complain too much, they are not valid reasons for dismissal. So you really need to be clear exactly what is the reason for dismissal, and it needs to be a lawful reason. Now, if you're talking about conduct, one of the other things that's important is the balance of probabilities. So if, for example, you're looking to terminate somebody on the basis of theft, for example, you need to have some evidence that will convince a reasonable person that on the balance of probability, it is likely that that is the conduct that occurred. You can't just sort of make assumptions and think, well, the money went missing and, I reckon it was probably Greg that did it, therefore he's got to go. You need to really make significant decisions of this nature on the basis of evidence and on the balance of probabilities. Having said that, we're not detectives, we're not the police force. We don't have to prove a wrongdoing, but on the balance of probabilities, there has to be reasonable evidence of the conduct that has instigated the termination action. Okay, so there needs to be a valid reason for termination. The next thing is that there needs to be clear communication. So this is really important. If you do have a policy, a managing performance and conduct policy, for example, or a termination policy, you need to be sure that you follow that policy. So we do generally recommend to our clients that they have policies. And if you do have one, please make sure that you comply with your own policy, that you follow the directions that are in your policy. So there have been cases where people have been found to, have a valid reason for termination. However, in the process of leading up to the termination, they've not followed the strict letter of the law of their own policy, and they've been found to be at fault. So if you do have a policy, make sure that you follow it. Make sure that you have that your policy is comprehensive. It includes what it needs to. And also importantly, make sure that it includes opportunities to streamline the process in certain circumstances. So for example, if somebody has done something violent in the workplace, you don't want them hanging around. So you want to make sure that there is opportunities in any policy that you have to circumvent the process where it's reasonable to do so in the circumstances. Okay, so policy. Good idea to have one. Make sure it's got the appropriate wording in it and make sure that you follow it. Also important around communication is making sure that the employee involved is very clear of your expectations. Sometimes people just assume that they know what they're meant to do. They don't always. So sit them down, tell them exactly what's required, tell them where they're falling short. When it gets to the pointy end, tell them that their employment is in jeopardy, and make sure they're clear on what's required and how, what you need to see to be satisfied with their performance. Okay, and the previous one there, Margot, was, oops, we're moving was record
Sorry, I don't know why I
keeping.
jumped back. My apologies.
Was record keeping, yes, clearly communicate, but also make sure that you have records of that communication process. So if you're inviting somebody to a meeting, make sure that you've got that written in an email. Make file notes of the meeting. If you're giving them warning letters, obviously write that down. Make sure it's on their file. If you're measuring their performance, make sure the performance measures are clear and that you're documenting any related incidents and so on. Okay, thanks, Margot. All right, busting a myth, 3 strikes and you're out. So that's another thing that we often get from employers is, oh, do I have to give them 3 warnings? Once upon a time, yes, I think that was the rule, but it hasn't been the rule for quite some time. The legislation does require that, other than instances of summary dismissal, for example, which we'll talk about later, other than that, you do need to give people a warning. They need to be warned that their employment is at risk and they need to be issued a warning at least. Now, it depends on the nature of the offence. I talked about the tatty t-shirt before. Sure, give a warning for that, but that doesn't mean that if they walk in with a tatty t-shirt again in a couple of days, that doesn't mean termination's an appropriate action because you've given them one warning. The warnings need to be in accordance with the offence, if you know what I mean. So sometimes a first and final warning is sufficient if the behaviour's of a nature that warrants that. Sometimes you may need to give multiple warnings, but it just depends on the circumstances. However, there is not a requirement that it must be three warnings before you can terminate. Okay, the next thing is opportunity to improve. You need to give people reasonable opportunity to improve. So make sure they're understanding what your expectations are, where they're falling short, and you need to give them a reasonable time to improve. So for example, if you're disappointed with somebody and they're falling short because they haven't met their KPIs for the quarter, let's say they're in a sales role, it's not reasonable to expect them to turn that around in the space of 1 or 2 weeks. It may actually need a longer period of time. So you need to set an appropriate review period based on the performance that needs to improve. However, if it's something like customer service or, they're abusing customers every day, well, that's something that should be able to be remedied pretty quickly. So you can have a shorter time frame on that, and that would be reasonable. Okay, you also need to provide reasonable support for people. So that might be training, it might be making sure that they've got the information that they need and the equipment, the tools and resources they need to actually perform well in their job. It may be that they, in the course of discussions around their performance or their conduct, that they mention some personal issues that they're having. They might be going through a marriage breakdown. They might have just had a new baby or something. You need to be reasonably supportive of those sorts of issues that we all have from time to time. So just keep that in mind as well. And then finally, I think you need to give them the opportunity to respond. So if you're getting to the pointy end and you're thinking, right, this person's ready, I need to get move this person on, you need to advise them of the reasons for your proposed action and give them a final opportunity to respond. That's really important. And going back to our record keeping, make sure that you're keeping records of related conversations. Okay. So best practice tip, you've probably heard about support people. It's a good idea to invite people, particularly when you're getting to the point of termination or close to. Invite them to bring a support person to any relevant meetings with them. Now, the legislation doesn't require you to invite them, but the legislation does say that you cannot deny them the right to have one. But our view is that it's always better to get on the front foot and advise them in writing that they can bring a support person to the meeting. Give them 24 hours notice so that they can organise somebody if they want to. And again, that's just all about helping you manage the risks. Okay, so if you take on board those steps, those 6 steps that or 6 items that we've suggested you cover off in terms of valid reason for dismissal, clear communication, record keeping, all those other things, you should be in a strong position to defend any unfair dismissal claim that comes your way. Once you do make a decision to terminate the person, so you've been through all that, you feel like you've got your ducks in a row, make sure that you deliver the news in person where possible. The Commission really frowns upon employers that terminate people through text messages and all sorts of things. So, it's nice and easy that way, but it's not necessarily the right thing to do. So try and do it in person where possible. It's really important that you confirm the decision in writing and clearly indicate the date of termination and the reason for the termination. Sometimes we get employers saying, well, I don't want to be specific. I just want to tell them, it's ended and I don't want to give a reason. Our advice is do not do that because that opens you up for other sorts of claims, which Margot will be talking about. So give them a reason, make sure that it's a lawful reason, not a prohibited reason, and make sure the date of termination is clear. Provide necessary notice or payment in lieu. So generally speaking, most people get a period of notice for less than 12 months. It's usually a week. Make sure that you give them that period of notice or pay them in lieu. Another just final point around payments due on termination. There's been some recent cases recently which have made it clear that employers are required to pay. If they do pay in lieu of notice, which is the usual course of events, it's important that that's paid before the termination. So when you're turning up to a meeting to advise somebody of termination, you need to make sure that the wheels are turning in the background to make that payment as soon as that news is delivered. And you also need to ensure that any annual leave payments due to the person are paid on or before the date of termination. So it used to be the common understanding that, we just do it in the few days after termination. No, there has been clarification recently that those payments at least need to be made on or before the day of termination. So just something extra to be aware of. Okay, so that concludes the component on unfair dismissals. If you've got any questions, shoot them through in the chat. Although we are pressed for time a bit, so we might move on to the summary dismissals and we'll try and cover the Q&As at the end. So over to you, Margot.
Sure, thank you, Greg. Let me make sure I can manage the technology. So I'm going to speak briefly to, in the first instance, summary dismissals, which are essentially those circumstances in which you might terminate somebody's employment instantly or without notice. And please, as I'm talking to all of this stuff, keep in mind those those fundamental rules that Greg talked about in terms of both the substantive fairness, does the punishment fit the crime, and the procedural fairness, because they both still very much apply to this. So essentially, a summary dismissal is an immediate termination, and it's usually only used in cases of serious misconduct. And serious misconduct, or conduct that is deemed serious enough for a summary dismissal, ordinarily includes things like, for example, theft, fraud, physical violence, serious breaches of health and safety, and those sorts of things. One of the things that's really important to point out in relation to summary dismissal is that concept of procedural fairness very much still applies. So even if you are quite certain in your own mind that the person or the behaviour of the person or the conduct is serious enough to warrant termination without notice, you still need to allow them that opportunity to respond. So you still need to go through a process of giving them some recourse and some opportunity to speak with you, to basically, my words, plead their case. And what we would ordinarily call that is a show cause meeting, where we would again give notice, usually 24 hours notice to the person of the requirement to have a meeting about this very serious issue, to outline to them in writing what that serious issue is, to allow them the opportunity to bring the support person with them if they would choose to, and also, of course, to outline to them that you are seriously considering termination of employment. So it's very clear that that is what the potential outcome might be. But according to the Fair Work Act, and certainly looking at a lot of the case law in relation to this, summary dismissal is really only used as a last resort. And it's something that has to be particularly well documented, as you can still be subject to either an unfair dismissal claim or a general protections claim, which I'll talk to in a minute, if the matter appears to be unjustified or if the remedy is seen to be too harsh. Greg and I were looking at a case literally this morning that was a summary dismissal, which actually resulted in a payment of somewhere in the vicinity of $400,000 to the person who brought the claim. And what the court actually said in that, and I'll read it, is the right of an employer to terminate the employment of an employee summarily or without notice is a right that should only arise in exceptional circumstances. Exceptional circumstances would generally involve some form of serious wrongdoing or misconduct on the part of the employee. And the ruling really underscored, it was a sexual harassment claim, amongst other things, the importance for employers to have really clear evidence of the serious misconduct before resorting to summary dismissal. And it highlights the need for very thorough investigations and proper procedural fairness when dealing with those sorts of workplace complaints, because the bar for unfair dismissals, summary dismissals, I should say, is significantly higher. My experience has been too, with summary dismissals in particular, where the person is feeling particularly aggrieved, they are less likely to succeed at the conciliation phase, which can then lead to all of those things Greg spoke about earlier in terms of the higher level of costs involved. One of the things I think people don't recognise and factor in significantly enough into those sorts of claims when they're made is that it's not just about the cost of the claim itself and the hiring of lawyers if necessary. Certainly in summary dismissals, if it's going to arbitration, lawyers would likely be involved for both sides. It's also the emotional toll on the people who are involved. If a case goes to arbitration, that means that not only is evidence needing to be presented, but everybody who is named in that evidence, or who has written a statutory declaration or some sort of a submission, is subject to cross-examination by the opposite side. And I don't know if any of you have ever been through that process, but been through cross-examination. It's harrowing. It's really hard work. So you need to be exceptionally careful, particularly with these ones, because with summary dismissal in particular, if it is found to be too harsh a remedy, reinstatement certainly is often untenable, which can often mean that the compensation is higher than it might ordinarily be. Okay, so we're also going to just talk briefly to general protections. And as Greg said at the outset, this is something that people aren't always as familiar with. So general protections claims are different from unfair dismissal claims, and they can be more costly because one of the key factors of a general protections claim is that the compensation is uncapped. They're also a bit more complex to defend, and there is no qualifying period for the claims. And that's particularly important. If you think back to that initial reference Greg made to the 6 and the 12 months, if a person is within those periods and lodges a general protections claim, they are perfectly within their rights to do that. There's no minimum period for lodging one of these sorts of claims. So one of the biggest challenges for employers in a general protections claim, and I'll talk specifically to the basis of what they are in a second, is that the burden of proof sits very much with the employer to prove that the dismissal did not happen for what's called a prohibited reason. And it means, therefore, that the employer has to provide all of the evidence to support their actions and make sure that they have very clear and very accurate documentation. It's absolutely essential in the event of a general protections claim. And because these claims are costly and difficult to defend, it's important to understand and avoid what those prohibited reasons are. So that's what we're just going to cover off next. So generally, a general protections claim arises when an employee feels that they've experienced adverse action for a prohibited reason. And adverse action can include dismissals, but it can also include things like a reduction in their hours of work, lost shifts, for example, a demotion, or any other action that they see as a disadvantage to them. And it also can include threats of taking those actions. Sorry, I'm just moving where people are on the screen so I can see the slide more clearly. So there's a whole lot of examples of what adverse action might look like. And common examples would be things like reducing an employee's shifts, denying them the same access to promotion, denying them opportunities to training and development, for example, or to resources that other people might have that they don't, coercing them, misrepresenting employment terms, all of those sorts of things, and of course, harassment. So let's look to some of these prohibited reasons. So prohibited reasons are reasons that deny an employee access to their rights or punish them for exercising those rights. So under the Fair Work Act, workplace rights refer to a whole set of protections that ensure employees can exercise specific rights without fear of retaliation or adverse action by employers. And that's things like entitlements and benefits. So they have the right, for example, to be paid a minimum wage, to take leave at agreeable times, to participate in proceedings like proceedings under workplace laws, like making complaints or participating in investigations or participating in union-related activities. So potentially being a member of a union or participating in bargaining, raising complaints or raising concerns or issues around their pay, querying pay rates, asking for pay rises. All of these things are indicative of workplace rights. So very clearly, the ability to make these inquiries or complaints is a workplace right. So, and any sort of lodging of a formal complaint or a grievance also could be deemed to be would be deemed to be a workplace right. People have a right to be free from discrimination, and therefore, it's around they can't be dismissed or disadvantaged because of their gender, their race, their sexuality, disability, any of those sorts of things. They can't be coerced into making an agreement, for example, being forced into doing certain certain forms of workplace arrangements. So when you are considering a dismissal or a demotion of an employee, whether it be an unfair dismissal or a summary dismissal, you need to be very, very careful that the reason for that dismissal is not based on the fact that this employee was exercising any form of one of these workplace rights. Because if you do that, it could well lead to a general protections claim. So as it says down the bottom there, some of the examples, and these are some of the ones we see most commonly, are questioning payer entitlements, accessing leave, and making complaints or lodging grievances of any kind. So what we have here are some few tips that can help you to reduce the risks of general protections claims. And the first one is, if you're considering a decision that might have an adverse impact on the employee, consider if there are any issues in play that might give rise to a general protections claim. For example, have they already made a complaint? Have they raised a grievance? Have they queried their pay? Those sorts of things. And if the answer to any of those is yes, then try to close out those matters before you enact your decision to terminate for whatever reason. Also, be very, very clear to communicate. And this is, again, a reason, as Greg stressed earlier, to communicate your decision for the termination of employment very carefully and in a very considered way, and to have that communicated in writing. So a valid, well-documented reason, particularly a non-prohibited one, is going to go a long way towards mitigating the risk of a general protections claim. As I said at the outset, these claims are difficult. What will quite often happen, we've noticed, is people will try and put their eggs, they can't do this, but they will try and put their eggs in both baskets. So they will quite often try and go down either pathway to see which one sticks. The Commission will usually put a fairly swift stop to that, and they have to choose one pathway or the other. But certainly for those people who haven't met the minimum employment period, if they are being advised before they lodge their claim, it will generally always be a general protections claim for some reason, because they won't have access to the general unfair dismissal provisions because of their length of service. So this is where, as I said, following a process, making sure that everything is very clearly documented and very clearly communicated can really help to mitigate those risks. Okay, we're moving into the Q&A component.
Okay, folks, we haven't been terribly active in the chat, so hopefully you're all awake and soaking the information in. But this is your chance. If you've got questions, throw them in the chat.
I have a question. Am I able to voice it vocally, or did you want me to put it in the chat?
Please do. Yep.
Sorry, my name's Alicia. I work for a medium-sized company, and you mentioned the minimum employment period. So does that mean if, for example, an employee was dismissed after 3 months, maybe 6 months, that there is no grounds for an unfair dismissal case?
You said a medium-sized company, so I presume you mean in excess of...
More than 15.
More than 15, yes.
More than 15. So, so the minimum employment period in that case is 6 months. So if they were dismissed within that 6-month period, including the period of notice, which would generally be a week in that case, if all that happened within the 6-month period, technically they don't have a right to apply for unfair dismissal. However, as I said, it is rather frustrating that the Fair Work Commission will still accept that claim, and you will still need to respond to it. But you should be able to object to it on the grounds that the person's not met the minimum qualifying period. That said, they would still have the opportunity for a general protections claim if they felt that they had sufficient grounds to mount such a claim. And
Okay.
as Margot alluded to, what is happening a lot is that if people that don't meet the minimum qualifying period go and see a lawyer or HR specialist or somebody that's going to advocate on their behalf,
Hmm.
they will at least test the waters to see if there's sufficient grounds for them to lodge a general protections claim.
Okay. All
And
right.
Alicia, I think the thing, as I said earlier, the thing to remember with that is that the onus is going to be on you to prove that they weren't discriminated against or whatever it was, rather than prove that that's what happened, which is
Yeah.
frustrating, but yeah.
Okay. All right. Thank you very much. That does answer my question. Appreciate it.
Okay, other questions, feel free to put them in the chat, or as Alicia did, just unmute and ask your question.
Hey Greg, that's Chris from Trill Group. We just got a question. We have a lot of issues with just general attendance. What would you classify that in terms of dismissal? In terms of, can we use that as a grounds to terminate someone within that 6 month period as a medium-sized business?
Well, we'd have to understand the particulars a bit more, of course, but are you talking about absences on leave?
It's just general absences. We're talking up to about, 20% of attendance, just every couple of weeks, Mondays, Fridays, just that's the kind of attendances issues we deal with.
Well, you can't lawfully terminate somebody for accessing something that they're entitled to. So, if they're accessing sick leave, well, you can't terminate them for that reason. However, if they're turning up late all the time, or they're not notifying you, in a reasonable time frame that they're not going to be at work today, and as a result you can't make other arrangements, then you can potentially do something about that. So you couldn't necessarily terminate, well, you can't terminate because they're accessing sick leave, for example, but you could start to take action against them, as in performance, maybe warnings, that type of thing, if they're not providing evidence when you're asking for it of the reason for their absence, or they're not notifying you by 9 o'clock or whatever it is. So it's always, we recommend in those sorts of, if you've got those challenges in your workplace, have a clear policy that says, well, look, and a lot of our clients have policies that say, well, if you're absent on a Friday or a Monday or the day after a public holiday, you need to provide evidence for reasons of that absence. And policies will also describe the method of notification. So you need to let us know by, 8 a.m. of your absence, and you need to call Chris or you need to call Jeff. Don't let people send you an SMS or tell their mate to tell you or something like that. You just want to make it a little bit harder for people and a bit more uncomfortable.
By email kind of thing.
No.
Phone call.
Yep. Okay. Any other questions, folks? Okay, last chance. Right. Okay, we might move on, Margot. Of course, you've all got our details, so if you think of questions after the presentation, don't be shy in coming forward. So in terms of further information or support, there's our basic details. We share a lot of this sort of stuff on our Facebook pages, LinkedIn, and that. So if you're not subscribed there, please like or follow us through one of those channels. You will also receive our Terminating Employment Guide to Reducing Risk for SMEs. There's a picture of it there. It's about 10 pages, I think. We think it's a pretty useful guide. It's sort of emanated out of, the areas that we often get asked about. So it covers all of the stuff that we've been talking today, as well as a bit more. So we'll make sure that you receive a copy of that together with the recording and the presentation slides. So just bear with me. That might be tomorrow when I send that out, but you'll get it within the next 24 hours or so. And finally, just another support mechanism that we have. Sorry, I should mention that, I'll add you guys to the newsletter list. If you don't already receive that, feel free to unsubscribe at any time, of course, but that does include some useful stuff. We only send out 1 or 2 emails a month, so hopefully that's useful to you. Our website also includes a knowledge base, so a lot of our articles are on the website. So another way we can support you is we have a HR compliance scorecard. So this is developed specifically for small businesses. It's a self-assessment. It just is a quick quiz to get a handle on your knowledge of your obligations as an employer. So it's a really useful starting point. We've recently updated it to cover some of the changes that came into being in late August around, for example, the right to disconnect, the changes to casual employment arrangements, and the changes to independent contractor arrangements. So if you've done this in the past, it might be an idea to do it again. It's free, no obligation, and you'll get a pretty good 20-page report that will help you meet your obligations as an employer. So I really encourage you to access those different support opportunities. And beyond that, of course, just reach out if you need anything. If you don't want to talk to us for any reason, well, that's fine. fairwork.gov.au actually have some good resources as well if you know where to find them. So feel free to log on there and see what you can find. Okay, final opportunity for questions, folks. Just while we're waiting to see if any other questions come in, we are keen on doing more of these in the new year. As I said, we're going to do one on redundancies, but if anybody has any feedback as to today's presentation, but also topics that you would like to hear of in the future, please send us an email or just